What if I told you there's a path to a permanent green card? No employer required, no job offer, no labor certification, no waiting for your boss to decide to sponsor you. And most immigration attorneys barely even mention it. It's called the EB-2 National Interest Waiver, and it might be the most powerful immigration tool available to skilled professionals in the United States right now. I'm Louis Hess, immigration attorney at Prosperity Immigration Law in Houston, Texas. In the next several minutes, I'm going to break down exactly what the EB-2 NIW is, who qualifies, how to apply, and what it takes to actually win. Let's go. Here's the problem. Millions of skilled immigrants in the United States face right now. You're talented, you're educated, you have a graduate degree, a specialized skill set, and you're doing work that genuinely benefits this country. But you're stuck waiting for your employer to sponsor you, waiting for perm labor certification to clear, watching your priority date creep forward 1 month at a time while the line stretches years, sometimes decades ahead of you. If you were born in India or China, the EB-2 and EB-3 backlogs can stretch 20 years or more. Your entire career held hostage by a single employer, a single sponsorship decision. And here's what really stings. The moment you change companies, get laid off, or decide to start your own business, your entire case can collapse. There is a better way. The EB-2 National Interest Waiver, or NIW, is an employment-based green card category that allows certain qualified foreign nationals to self-petition for permanent residency. No employer sponsor, no labor certification, no perm. Congress created this category for people whose work serves the national interest of the United States. Researchers, scientists, engineers, physicians, educators, AI specialists, entrepreneurs, economists, and others whose contributions go beyond any single company and benefit the country as a whole. To qualify for the NIW, you must satisfy a three-pronged test. By a landmark USCIS decision called Matter of Donau in 2016. Let me walk you through each one. Prong 1, your proposed endeavor must have substantial merit and national importance. This means your work needs to connect to a recognized U.S. national interest. That could be healthcare, national security, STEM research, climate and environmental solutions, economic development, education, agricultural innovation, or technology advancement. The key word is national. Your work has to matter beyond your own career. If you're a cardiologist helping underserved communities access life-saving care, that's national importance. If you're an engineer developing water purification infrastructure, that's national importance. If you're building AI tools that help small businesses compete globally, USCIS has accepted arguments like that too. Prong 2, you must be well positioned to advance the endeavor. This is where your credentials come into play. USCIS wants to know why you specifically are the right person to do this work in the United States. That evidence can include advanced degrees, peer-reviewed publications, and how many times your work has been cited, patents you hold or have contributed to, media coverage of your work, membership in professional organizations requiring outstanding achievement, awards, speaking invitations, letters from experts who can attest to the significance of your contributions, and evidence that others in your field rely on your work. You don't need all of these. You need a compelling combination that tells a coherent story. Prong 3. It would be beneficial to the United States to waive the usual job offer requirement. In other words, USCIS needs to be convinced that the national benefit of having you continue your work here outweighs the normal policy of requiring employer sponsorship and labor market protection. This is an argument, and it has to be made strategically. Once you've established eligibility, here's how the NIW process actually works. You file Form I-140, the immigrant petition for alien workers, as a self-petition. That means you file it yourself or through your attorney without an employer's signature or involvement. If you're already in the United States on a valid visa, an H-1B, an O-1, an F-1 with OPT, a TN, anything valid, you can file your I-485 adjustment of status concurrently with your I-140, as long as a visa number is immediately available for you. For most countries other than India and China, this is possible right now. Premium processing is available for the I-140. As of 2024, that means a decision within 45 business days. Not a guarantee of approval, but you'll know where you stand fast. For applicants from India and China, the priority date backlog in EB-2 is still a significant obstacle. But filing the I-140 now establishes your priority date, which is critical. The earlier you file, the earlier your place in line. Now, let me give you the three most important things you need to know before you file. Number one, you do not need to be a Nobel Prize winner. The NIW does not require extraordinary ability. That's EB-1A, a different and higher standard. The NIW requires substantial merit and national importance. And that bar, while real, is achievable for working professionals who can demonstrate genuine impact in their field. We have won NIW cases for pediatric cardiologists at small regional hospitals, for environmental engineers working on water projects in rural Texas, for software developers building accessibility tools for people with disabilities, for university professors and non-elite institutions who had a solid publication record and documented community impact. The story matters as much as the credentials. Number two, you can file even if you don't have a current employer. Between jobs, starting a company, doing freelance or consulting work, none of that disqualifies you. What USCIS cares about is your proposed endeavor going forward, what you intend to do in the United States, and why you're positioned to do it. Entrepreneurs have won NIW cases by demonstrating the economic value and job creation potential of their proposed venture. Self-employed consultants have won by showing that their specialized knowledge directly serves U.S. industries. This is the only employment-based green card where you truly own your own future. Number three, the evidence package is everything. An NIW petition is not just a form, it is a legal argument, a strategic brief, and it lives or dies on how it's constructed. A strong petition includes a detailed personal statement articulating your proposed endeavor and its national importance, expert recommendation letters from credible voices in your field who speak to the significance of your work, not just how great you are as a person, documented evidence of your prior impact, citations, patents, media awards, and a clear logical connection between prongs 1, 2, and 3. I've seen genuinely strong candidates get denied because the petition was disorganized or didn't directly address the Dono framework. I've seen cases that looked marginal on paper win, right? Because the attorney built the argument the right way. This is not a case you want to file with a template you found online. If you're a researcher, a physician, a scientist, an engineer, a technologist, or an entrepreneur, and you're exhausted from depending on an employer to hold the keys to your future in this country, the EB-2 National Interest Waiver may be exactly what you've been looking for, but you need to do it right. Our team at Prosperity Immigration Law has helped professionals across Texas and across the country file compelling NIW petitions. We'll evaluate your profile, assess your eligibility honestly, and if you're a strong candidate, we'll we'll build the most strategic evidence package possible. Call us at 281-205-8540 or visit prosperityimmigrationlaw.com and schedule a free consultation. The green card to your independence might be closer than you think.